And welcome to Playing in the Sandbox with Annie and Eli. Today/tonight, I guess, we're recording this in the evening. We're going to be discussing some of the recent changes to the Utah Rules of Professional Responsibility, specifically Rules 5.4, 1.5, and 7.1 through 7.5. We'll also talk about the new Standing Order 15 from the Utah Supreme Court, which was just signed a couple weeks ago on August 14th. And what that does is it creates a regulatory sandbox, which allows the Utah Supreme Court to regulate through an innovation office and some non-traditional legal service providers and traditional service providers that are providing non-traditional legal services. And if you don't know what that means, I don't know that anybody does at this point, but we're excited to dig into it with you tonight. We recognize that a large portion of the J. Reuben Clark Law Society is located outside of Utah and some even outside the United States. And while we understand that this is very Utah-specific rules, this is certainly a trend. In fact, just since the Utah Supreme Court signed its order, both Arizona and California have made some similar steps in the same direction. And regardless of whether or not your state or whatever your municipality or governing authority adopts, certainly I think that this indicates a large shift in the legal market that's going to affect everybody at some point. So we're excited to dig in. First, I guess we'll just introduce each other. This is Eli McCann, and he was one of my good friends at the J. Reuben Clark Law School. He, I think, joined every club possible. I don't know how he did that, but it was impressive to watch. And since then, he's clerked near and far. I'm here at the Utah Court of Appeals and as far as Palau. So ask him about that if you get the chance. He's currently a shareholder for Kurt McConkie here in Salt Lake City and practices commercial litigation.
Thank you, Annie. Annie and I have followed one another through our careers so far. We graduated law school together back when Annalise's last name was Quinn. It is now Wilson. She just keeps adding names to the end of her name. Annie was the smartest person in my class, or at least one of. We all thought that she quit law school on like one of the first days because we had to take a property exam, and it was supposed to be like a 2-hour exam. And after about 15 minutes, Annie got up and walked out, and we all assumed that she had just decided law school wasn't for her and quit. As it turns out, she's just brilliant, and she was aced the exam in 15 minutes, and it took the rest of us 2 hours to do worse. But so Annie and I worked for Kurt McConkie together for a long time, and then Annie left us to go be general counsel for Ivory Homes, and we've missed her very much ever since.
Oh, the feeling's mutual, Eli.
Thanks.
Why don't you get us started off with why the Utah Supreme Court felt it necessary to make these pretty extreme changes?
Yeah, there has been a conversation for several years about the idea that the access to justice gap is just growing and growing and growing. It's, of course, no big secret that legal services are very expensive and that there are portions of the population that can't afford even some of the most basic legal services. But what we're finding and what the Supreme Court has found, and looking at some studies that have been done over the last decade or so, is that with each passing year, there's a larger and larger portion of the population that can't afford even the most basic legal services to meet some of the most common legal problems that people face. The Standing Order 15 addressed a few of the studies that it looked at, including one that was conducted in 2016 and 2017 by the Legal Services Corporation. And it found that 86% of civil legal problems reported by low-income Americans received inadequate or no legal help at all. In a 2020 analysis done just this last April, the court noted that Utahns living at about double the federal poverty level are largely unable to afford any legal services whatsoever. Specifically, their legal needs are going unmet at a rate of about 82%. And so the court has been looking at this and seeing it's not just the case that there are a lot of people who are stretched in trying to pay for legal services, but there is a huge portion of our population in this state and throughout the country that when they face a legal need and have to navigate a very, very complicated legal system, their option is either to let the system sort of swallow them or victimize them, or to try and navigate it completely on their own and just hope for the best. And so the programs and the rule changes that we're going to be talking about, at least, are aiming to try and meet some of those needs and close that gap, so that people who currently are not getting any kind of legal help whatsoever will at least have some extra options available to them.
Mm-hmm. And there are certainly many pro bono programs out there right now. I know many attorneys dedicate a lot of time, but as Justice Simonis has said, this just isn't a problem that we can volunteer ourselves out of. Eli, you've had some unique experience with pro bono. Could you share that?
Yeah, so I've dealt with some civil rights claims over the years, specifically in the context of prisoner medical neglect claims. A few years ago, I was asked by a federal judge to provide some pro bono assistance to a prisoner who had been attempting to navigate the legal system on his own for a couple of years. And in this particular case, the prisoner was alleging some pretty serious medical neglect claims. He was a stroke victim and essentially received no help over the course of the night, despite requesting help on multiple occasions. And this prisoner was, unlike a lot of the prisoner population, he was really, really well educated. And so he was able to actually navigate the system pretty well through some hundreds of pages of handwritten filings. But his case proceeded to a point where, even with his all of his due care and diligence that he put into it, it was too complicated for him to be able to continue to navigate. And so the court sought some pro bono help to get him some pro bono help. And so I was able to assist with that. And what I learned through that process was there are groups like the ACLU and associated related groups that try and provide pro bono legal assistance to families that have meritorious claims or need to navigate these kinds of systems. But those groups can only help a very, very, very small percentage of the larger population that would benefit from some kind of legal help. And in the case of this particular prisoner, if he had not been able to receive pro bono help at that point, his claims would have been completely lost, sunk in the water. And so he was, I suppose, one of the lucky ones who was able to get some pro bono help. The idea of these programs and these rule changes are, perhaps if we created something just a little bit above the level of pro bono work, but some kind of option that a person like that might be able to go to that is affordable to them, or that their families might be able to go to that is affordable to them, to say, hey, I don't think that we can continue doing this by ourselves. We need some direction, and you at least have a competency that's a little bit above where we are right now. And so the hope is that these kinds of programs and changes might be able to close that gap a little bit, so that people don't end up just getting lost in this system.
Yeah, I definitely think that that's the hope, and it's bigger than just trying to make traditional services more affordable. I think that the Utah Supreme Court's really thinking outside of the box here and inviting innovation. So instead of just working within the traditional framework, but completely outside of it, they're willing to entertain all kinds of ideas. The 4 categories that they've identified are areas of practice that have this real need are small claims, family law, debt collection, and immigration. That those are high-risk areas that they're hoping will receive some help. I know there's a lot of opposition from the bar and others, maybe not the bar specifically, I should say members of the bar, about whether or not these changes will actually make a difference. But I think we're hopeful that they will, and certainly we'll get to some comments and debate that back and forth once we talk about the changes themselves. So the first change is to Rule 5.4a, and this change, so 5.4 governs attorneys. I think that's what a critical distinction to make at the outset. The changes to the Utah rules of professional responsibility only apply to lawyers. So any non-traditional or non-lawyer providers that come through the Sandbox, they're not going to be subject to these changes. So this first change, 5.4a, this governs just the traditional delivery of legal services. And the big change is that it allows for sharing of fees, both between lawyers and non-lawyers, when certain conditions are met. Those conditions are written notice to the client as well as any other person who's paying for the fees that describes the fee sharing relationship, and it must be that written notice must be provided before the representation starts. And in addition to that, the overlaying duty of this Rule 5.5a is to preserve the normal duties that a lawyer always has to his clients. So the duty of independent judgment, duty of confidentiality, and the duty of loyalty. And so the lawyer must be able to independently certify that regardless of the referral fee or the sharing fee split that they've come up with, that they're still able to uphold those duties they'll always have to the client. Rule 5.4ac also allows for third-party retention, which we sort of see this already in the insurance defense context where a third party is paying for the fees, but this explicitly allows a third party to retain an attorney and to pay that attorney on behalf of another person. So again, the upshot for Rule 5.4a is this is again within the traditional model. I think that's what we need to keep in mind, is that 5.4a, you're still thinking of that traditional law firm or solo practitioner that's a licensed member of the bar providing traditional legal services. The main difference is that now they can share fees with lawyers even if they're not a part of the representation, and they can pay for referral fees. And again, that's as long as the structure is still the traditional lawyer-owned structure. Those benefits are already automatically available. And with those, Rule 1.5 was edited to eliminate the prohibition on sharing of fees so that it's consistent and mirrors with that new Rule 5.4a. Now, the new Rule 5.4b is applicable to lawyers who are participating in the sandbox that we're going to get to in a minute. So these are lawyers that are licensed to practice law and therefore are subject to the rules of professional responsibility, but they're not practicing in the traditional structure. There's something different about that structure that requires them to go through the sandbox to get this exception. This will likely look like an organization that's owned or managed in whole or part by a non-lawyer. So if your law firm gets bought out by a corporation or some type of non-lawyer who manages the practice, then you would be subject to this 5.4b and the Standing Order 15. And this is allowed. You're now allowed to partner with non-lawyers in these ways, as long as the client's given written notice that the non-lawyer has either this financial interest or this managerial responsibility over the lawyer, and in addition to that, they receive in writing the details of that. So either the details of the financial interest of the non-lawyer or the details of that managerial structure that allows the non-lawyer to supervise the lawyer. As long as those conditions are met and you're still, again, of course, able to uphold those duties that we talked about before that always apply to attorneys, the duty of independent judgment, duty of loyalty, duty of confidentiality. As long as you can maintain those and you go through the sandbox, Rule 5.4 opens up those avenues as well. Would you like to tell us about the standing order itself?
I'd love to. So it's quite a massive change and a pretty big thing that's being proposed and undertaken by the Supreme Court. So the Supreme Court looked at the problems that we've been discussing and figured that possibly one of the ways that it could attempt to create a system where people can find access to legal resources, people who previously have been unable to pay for them, would be to, on a trial period of 2 years, create this regulatory sandbox. And the way this is supposed to work is all listed and described under Standing Order 15 by the Utah Supreme Court. And what the court is hoping to do through this is create this office that it's calling the Innovation Office to monitor and regulate and create some rules for people who are not traditional lawyers, not lawyers, to enter the sandbox and provide some legal services, or for lawyers like Annie just discussed, who are partnering with non-lawyers to enter and provide legal services in that kind of non-traditional dynamic. And so it's the Supreme Court is sort of borrowing from some prior practices where in certain contexts over the years, we have in industries created opportunities for people within an industry to do something that kind of looks legal-esque in nature. We've seen this pretty frequently, for example, in the real estate industry, which I know, Annie, through your work, you're familiar with what real estate regulations and rules look like. And one of the things that real estate agents have had to kind of navigate and deal with over the years is the idea that they're engaging in these transactions that in certain ways look legal in nature. They're entering into agreements, they're modifying those agreements, they're sharing them with their clients, they're trying to help their clients understand what those agreements say. Where in that industry, it's not practical to have a lawyer join with real estate agents and buyers and sellers every time there's a purchase of a property. The court created a system where real estate agents could, on a very limited basis, engage in those transactions that look a little bit legal in nature without engaging in the unauthorized practice of law. I know, Annie, you're more familiar with what those regulations look like. I don't know if you want to say anything else about kind of the parallels that we're seeing with the Sandbox.
Sure. I think that it's probably the best example we have now. In fact, it's an example that's used in the standing order itself. And the Utah Supreme Court Rule of Professional Practice 18-802 allows the Utah Supreme Court to regulate and authorize the practice of law. And in general, in almost every instance, that's been reserved exclusively to lawyers. One exception that's currently allowed is for real estate agents to use the state-approved forms. So form contracts that have been approved by the Utah Division of Real Estate and the Utah Supreme Court, real estate agents are allowed to fill those out, which in some ways could technically be considered the practice of law. I have the definition around here somewhere. So yeah, Rule 14-802 defines the practice of law as the representation of the interests of another person by informing, counseling, advising, assisting, advocating for, or drafting documents for that person through application of the law and associated legal principles to that person's facts and circumstances. So real estate agents do that when they fill out the contract, but they're limited. I mean, they're only given one of the sticks of the bundle of sticks, if we want to go back to property law, of the right to practice law. So they can do that one thing, but it's very clear. I went through the real estate course myself when I got my real estate license, and so many times in the materials, it's explicitly clear you are not allowed to draft contracts for your clients. You can use the state form. You're not a lawyer. You're not allowed to engage in the practice of law. So I think that is an example of how the Supreme Court is viewing that they're essentially opening up their doors and saying, come into our sandbox, let's see what other ideas are out there, and then we will grant that limited authority on these non-traditional service providers.
So the Supreme Court has sort of said, okay, well, we've figured out a way to kind of do this thing in that real estate context. So how can we create a sandbox where we create more opportunities like that, and perhaps even bigger opportunities than that particular one, so that people are able to access legal resources a little bit more. So the Innovation Office, which is going to function with the authority and under the Supreme Court, has been tasked with figuring out how to create some rules to review applications of people who want to enter the sandbox, who are applying to come into the sandbox and provide legal services despite the fact that they're not traditional lawyers, or provide non-traditional legal services through the means that we've discussed already. And so the Innovation Office will then be tasked with reviewing those applications, with recommending whether or not those applications be approved, developing and overseeing and regulating what happens within the sandbox. There will be a way for consumer complaints to be reviewed by the Innovation Office as it looks at whether or not there are problems with people who are entering the sandbox and overstepping the authority that has been granted to them to act or practice within that sandbox. The Innovation Office is going to be composed of 11 members, 5 of which at least must be non-lawyers, who can sort of review these applications and try and understand what it is that people who are trying to enter the sandbox, what needs they're trying to fill. And remember, this Standing Order 15 expires after 2 years, with the idea that this would be a trial period where I think sort of the court acknowledges we don't quite know what's going to happen within that sandbox, We hope it's not a disaster. We hope that it's a good program. We understand and recognize that it's possible that we're going to get to the end of these 2 years and say, okay, that didn't really work, or that created more problems than it solved. And so the idea is that the Supreme Court, through this innovation office, is going to be able to monitor what's happening within that sandbox, keep track of the people who are entering and exiting that sandbox, keep track of the consumer complaints, see what those complaints look like and whether or not there can be tweaks to the system that might be able to help address some of the concerns or risks that might be posed. And then at the end of that 2 years, determine whether or not it makes sense to continue this kind of program. So one of the kind of, I think, most interesting aspects of this Sandbox program, Understanding Order 15, is the idea that people who are entering the sandbox are not going to be held to the same standard that traditional lawyers that you and I are held to when we're practicing law. And we are sort of used to seeing competency in our field in terms of bar discipline or malpractice claims. And we understand, kind of what the level that we're held to, that sort of heightened level to provide valuable resources and assistance to clients. People who are entering the sandbox will not be traditional lawyers in that traditional sense. In Understanding Order 15, the Supreme Court noted that the way the Innovation Office is supposed to look at the risk that a person might pose in practicing within that sandbox is not the same kind of risk that you might look at when you're determining whether or not to allow an attorney to be admitted to the bar or keep their standing within the state bar. Instead, what you're looking at is, again, a population that previously has not been able to obtain any legal resources whatsoever. And that's the baseline that you're dealing with. And so the Innovation Office is tasked with looking at whether somebody within the sandbox is helping their clients and providing a better resource than those clients would have had without any access to any legal resources whatsoever. So it's more of a looking at this system and determining whether or not an individual practicing within that sandbox is doing more harm than good, or is able to do more good than harm or risk that they might pose. And I think that's going to create some really interesting tasks for this board and for the courts to sort of review these practices and kind of determine whether or not it makes sense to allow people to practice within the sandbox just because they're providing a resource that at least is better than somebody not being able to receive any legal benefits whatsoever. Do you have any thoughts about that, Annie?
Yeah, it is definitely a different standard than what we're used to. But it's not just, let's throw everything at the wall and see what sticks. They do have one objective that the Supreme Court has clearly articulated, and that's to ensure consumers have access to a well-developed, high-quality, innovative, affordable, and competitive market for legal services. So that's their goal. They're looking at the market for legal services as a whole, and the objective is to better develop that legal services market. And to do that, they've looked at 5 specific regulatory principles, and you did a great job of summarizing them. The way that they're laid out in the order is that 1, the regulations need to be based on the risk to the consumer. So both looking at the probability of risk and the how terrible the impact would be if that harm did occur. The second principle is to, like you said, they look at this risk of harm versus the relative to the current legal service options available. So like you said, if there's no legal service option available, then that's going to be kind of scary, but it's going to be a pretty low bar. If it's an area of the law that's already pretty well served, like for example, PI law, there's really not an access to justice gap there because of the way that industry has set itself up. I don't think it can be said that it's difficult to get a PI attorney because most of the cases are on a contingency fee. Most people are fine with giving up. Maybe they don't love it, but there's certainly plenty of people that are getting access to attorneys in PI cases. So I think that they look at the legal services market and decide how needed is this service.
Well, and one of the, I think, challenges that they're going to face as they navigate that is, again, this system is being set up to close that gap. And ideally, under Standing Order 15, the only people who are receiving services within the sandbox are people who otherwise would receive no legal services. I think we can assume that there are going to be situations where people are choosing to engage legal help within the sandbox that otherwise might have been able to afford traditional legal services. And so I imagine that there's going to have to be some overlap there. And so in those cases, does it really make as much sense to hold the people who are practicing within the sandbox to that same lower standard that we might be tempted to hold people to when they're giving legal aid to people who otherwise would not have been able to receive any legal aid? And I think that that's a kink that is going to be, it must be awkward to work out. I think we're going to see some kind of awkward navigation through that.
Yeah, and this is all supposed to be very empirically driven. In fact, that's one of the guiding regulatory principles. But just to sum up what you just said, if there are still people that might shop at Walmart even though they can afford Target, right? And so certainly it's hard to completely fill in the gaps of the legal services market without some redundancy and perhaps some consumer harm. In fact, that's something that's recognized in the standing order, that they're going to establish a probabilistic threshold for acceptable levels of harm. And so right there in the order, it expects and almost sanctions some type of level of harm. There's this understanding that these legal services aren't going to be perfect, and that some level of harm is acceptable to address what is already this great harm of inability of so many people to access justice.
Right. So again, Standing Order 15 is going to deal with people who are non-traditional lawyers practicing or providing legal services, and then lawyers providing non-traditional legal services in the ways we've discussed. One of the interesting things is the Standing Order acknowledged that it's creating a place for non-lawyers to own and manage law practices. And the Standing Order specifically says that individuals who have been disbarred have already shown that they pose a substantial risk to our industry. And as a result, they're not going to allow disbarred lawyers to own more than 10% of the law practice and enter the sandbox and participate in that way. I imagine that we're going to see more restrictions about types of individuals that are able to practice within the sandbox, and we're just going to have to see how that develops.
Right. And I think that just as this all develops, well, let's go through how an individual or entity would enter the sandbox. So step one is that any individuals or entities that fall within that regulatory scope that Eli just outlined, so either lawyers that are partnering with non-lawyers or non-lawyers wanting to provide legal services, they would make application to the Innovation Office. The Innovation Office would look at that application. They might ask for additional information. It's contemplated that the applicant would pay a fee. And the Innovation Office, again, its main objective is to weigh whether or not this proposed legal service would further the larger objective, which is to provide a high quality legal services market. And it doesn't present this unacceptable level, this threshold of harm. It's not below this unacceptable threshold of harm to consumers. And then the Innovation Office, once it's completely evaluated the application according to that objective and those regulatory principles, it then will either recommend the application to the Utah Supreme Court, or it can deny the application. If it denies the application, I think that I didn't notice any bar on reapplying, but at that point they'd be out of the sandbox. It did say, the standing order does say that the Innovation Office should create some type of appeal, so that if a person is denied by the Innovation Office, they could then appeal to the Utah Supreme Court. If the Innovation Office did approve the application, so it went up to the Utah Supreme Court, the Supreme Court would then do its own evaluation and either approve the applicant for entrance to the sandbox, or send it back down to the Innovation Office with maybe either just a straight up denial or some feedback.
Notes, yeah.
And I understand that this could potentially be an innovative or iterative process where these applications aren't just dead, they're living things where it might go back and forth a couple times until both the Utah Supreme Court and the Innovation Office is comfortable with the service provided, the reporting requirements required, and then any other additional restraints that they think is necessary for the particular application. Once an application is moved and that company or person receives entry to the sandbox, they actually get authority to engage in the practice of law, again, through the Supreme Court's plenary authority. They grant that authority down to this individual or entity who's in the sandbox. And then once the sandbox participant has been able to demonstrate that their product or their services are safe, and then it's providing value within the regulatory, again, these principles that the Innovation Office has set, it's not below that threshold of harm, then they can actually exit the sandbox. And when they exit the sandbox, it's the same idea where the Supreme Court will actually provide them a license to practice law, even though they're not attorneys, even though they didn't go to law school, they have this license to practice law in Utah. And certainly it's anticipated that that license might have some conditions, that it could have education requirements, just like lawyers are subject to their CLE requirements. It does certainly anticipate reporting requirements. And in particular, each sandbox participant and person who's exited the sandbox has an affirmative duty to report any harm. If they run into some unforeseen risk or unforeseen harm as they're providing their legal services, they have an affirmative duty to report that harm to the Innovation Office. As Eli said earlier, the Innovation Office will also develop a method to receive consumer complaints. Just as the bar receives bar complaints about attorneys, the Innovation Office will receive consumer complaints about the different individuals and entities that it is regulating at the time. And the range of enforcement mechanisms, I think, are pretty similar to what attorneys are subject to, maybe a bit broader. It anticipates that there would be increased reporting requirements, fines, suspension, or termination of license. And the Innovation Office will also develop an appeal procedure. So if the legal service provider doesn't agree with whatever enforcement mechanism has been enforced upon them, that they will have the opportunity to appeal that to the Supreme Court, because again, this is all under the Utah Supreme Court's authority. Finally, I thought it was helpful that it pointed out that enforcement actions would only take place when the consumer harm exceeds the applicable consumer harm threshold. So the Supreme Court acknowledges that, again, there is this possibility of harm, and that if whatever consumer complaint is received, if it's not above that threshold level, that the Innovation Office isn't going to take any enforcement action against that legal services provider. And the Supreme Court in this order directs those unhappy consumers to just the traditional methods of civil litigation, or I guess the criminal justice system, depending on the type of complaint. And again, going back to a comment you made, I think that this brings up, and this was a comment that was made, I'm jumping ahead a bit, to the comments made, the public comments in response to these proposed orders. An attorney I really respect, I thought, made a very thoughtful comment about what would that look like if a consumer is injured by one of these non-traditional legal service providers, and they decide to take the Supreme Court's advice and they go file a civil lawsuit, a traditional civil lawsuit, to pursue their grievance. What is the standard of care that would be applicable to that lawsuit? We have all this very well-developed case law of attorney malpractice claims, and what is the applicable analysis and the applicable standard of care. But it's pretty clear from this order that none of that would be applicable here. These are completely, it's just a different animal. And I can't see a court just straight adopting the standard of care that attorneys are held to, who have gone through the traditional licensing procedure. And so I think that provides another potential hoop or harm to this consumer of unpredictability of not knowing what the standard of care would be in that type of action. And also, it's unclear whether or not these legal providers would be required to have some type of malpractice insurance. So whether or not, even if they were successful, there would be a means to pay that type of a judgment. So just an interesting thought.
Yeah.
The applicable standards, again, lawyers that are within the sandbox are still have to abide by the rules of professional conduct, and that doesn't change at all. The identities of the applicants to the Supreme Court, that's all public information, so there really isn't any confidentiality. If you're going through this process, you're opening yourself up to whatever your idea is going to be open to the public. And the Innovation Office itself is subject to certain regulations where it has to report regularly in various identified categories to the Supreme Court. So I think the hope is that this is going to be very controlled, and a lot of data will be collected, and all the decisions made will be empirically driven.
Yeah. So Annie teased a little bit of some of the public comment period, and one of the comments that has been received so far on this, we spent some time looking through what the other comments and concerns look like, and a lot of the concern about the rule changes that will allow attorneys to partner with non-attorneys to manage practices have to do with this idea or possibility that non-attorneys might be able to pressure lawyers who they're essentially managing to act unethically, to violate the rules of professionalism. And so there has been some concern that traditionally, lawyers are sort of their own boss. They run their practices, they manage their practices, they understand what the rules of professionalism look like, they understand what their ethical duties are, and so forth. So what happens when you introduce into that system the possibility the lawyer is now reporting to a manager or boss who's telling the lawyers sort of how to practice, and what happens when that lawyer's employment is put at risk if they're unwilling to do something that the lawyer believes to be unethical. Some of the response to this has been that lawyers as a whole are a group of people who should be best equipped to deal with that kind of struggle. Lawyers know what their professional obligations are, they know what their ethical duties are, and lawyers should, of anybody, be able to go back to a boss and push back on those types of pressures, those types of concerns, and be able to outline what their professional duties are, put their foot down and say, I can't do that, I can't cross that line, I'm not willing to take that risk for my ability to practice law. And so I think it'll be interesting to kind of see whether or not that actually does play out, whether or not you find large law practices that are being run and managed by people who may not have as firm of a grasp on what those rules look like, and whether or not we see more ethical problems coming out of those and bar complaints and so forth.
Sure.
So I think we'll stay tuned on that.
I think that that's one of the less persuasive criticisms, and certainly there are some really persuasive criticisms that we'll go through. It was interesting to read. There were hundreds of comments, and a lot of them almost read like a Facebook post. A lot of people just really angry, really upset, and some with some very valid concerns. Again, this is one that I wasn't too persuaded by, and maybe that's just because my boss isn't a lawyer as in-house counsel.
Yeah.
This isn't something that's new in our world, so the idea that just because you work with non-lawyers that all of a sudden that's going to create this crisis of conscience. I don't know. I don't know if I buy that one. What's the next one?
It'll be interesting. You know, I hadn't really thought that much about that in the context of general counsel of companies. But in a way, that relationship looks, a lot more like a relationship that I have in my law firm with a client.
True. Yeah.
And so, but for you, it's sort of an extra level of that boss, that you have. And so, yeah, I guess we do have, one context where that's kind of working. A bunch of the concerns had to do with the idea that possibly Utah is rushing into something that it shouldn't be rushing into. So Utah is sort of leading the way on a lot of this right now. We don't really have great examples across the country of how and whether this is working. And so there were a bunch of comments about whether or not it made sense for Utah to proceed and do something this dramatic and drastic and allow all of this to enter into the legal market in our relatively small legal market, instead of just possibly waiting a few years to see whether any other states want to adopt the similar changes and programs and see how it works in those states. Somebody's got to go first, and I think some of the response to that might be, well, why should we wait to do something that might be good for our state just because nobody else has done a thing that might be good for their state first? I don't know. I think that there's going to be some discomfort in having to navigate this a little bit in the dark.
Yeah.
And we'll see whether any states follow our lead or look to us as a cautionary tale in the coming years.
Yeah, and on that, I think that a few practitioners also pointed to, just within the last year or two, the Supreme Court created this LLP program that allowed for licensed paralegals to represent clients even in court under certain limited settings. So some of the other attorneys also on that innovation note said, we just did this one innovation, let's let it play its course and see if it can make a dent in this access gap before trying something new.
Right. So, we'll see. It is what it is, and so we're doing it. We'll see whether it was a mistake. We've talked quite a bit about the idea that the Sandbox program, Standing Order 15, is created not to provide competition for people who are already in the legal market, but to create an industry that currently does not exist. A lot of the practitioners talked about the Target Walmart problem that Annie mentioned a little bit earlier, which is, okay, do we actually know that that this Sandbox is only going to serve individuals who are currently not receiving any legal help at all? Because if it is the case that suddenly we create this Sandbox and people who are currently using resources of solo practitioners and small law firms then flock to the Sandbox because it's a cheaper option available to them, then is this going to create some competition for these solo practitioners and small law firms that they cannot keep up with? And it's an interesting idea. You can imagine that by and large, a solo practitioner or a small law firm is probably going to be able to provide a greater range of competent legal services than the types of individuals that we're imagining might enter the Sandbox to provide more limited legal resources. But the average consumer who is not a trained attorney might not be able to understand that or acknowledge or appreciate the difference between those types of legal services. And so if you've got people looking for legal services and they see a solo practitioner, a small law firm, a traditional lawyer, and they see what those fees look like, and they see somebody else who's essentially offering to get the same results for a much lower cost because they're not a traditional lawyer, because they're practicing within the Sandbox, you might find that consumers are going to flock to these newer groups that are cheaper. And is that really what we want? Because essentially that could ultimately result in a situation where the legal resources that are currently being provided are diluted, and we end up in a situation where poorer, lower quality legal help is being provided to the public at large. I don't know that there's any way for us to tell right now whether or not that's going to happen, whether it really will be the case that these rule changes in this program are only going to fill a hole that currently exists, or whether it's going to crowd out other areas of the industry.
Yeah, and I think that the flip side of that, the other concern is that it's going to actually increase the cost of legal services for those small firms and the solo practitioners, especially the changes to Rule 5.4, which isn't directly related to the Sandbox, but again does allow lawyers to now pay non-lawyers for referral fees. And so is that just going to turn into people selling clients for the highest bidder? And unless you're a large law firm who can afford that extra layer of overhead to purchase the best cases, and is that just going to be something that's going to increase the cost of legal services for everyone, because now you're having to share fees and pay referral fees on top of covering everything else that lawyers have to cover for their overhead?
Yeah. At least one of the comments implied or talked about the possibility that we may be overstating the problem a little bit. The statistics and reports that were issued in the standing order or referenced in the standing order suggested that a big portion of the population is not receiving legal services when they have a legal problem. At least one of the comments we read talked about, well, are we sure that if somebody is not represented or they're not receiving representation, that really does equal a lack of justice being served? Because a lot of legal problems that people encounter, they are able to successfully navigate on their own. You don't need to hire a lawyer for every legal problem that you have. And so do we have enough data, enough statistics, enough studies and reports to establish that there really is as big of a gap? Do the studies that we're looking at right now actually mean what the Supreme Court is interpreting them to mean? Or is it the case that the problem is a lot smaller than we're anticipating? And if so, does a program that is, some see as this dramatic make sense to engage and initiate at this point? Do we need to spend a little bit more time studying these issues? I think it's a general understood concept that legal resources are incredibly expensive. People are always stressed about having to pay for a lawyer if they come across a legal problem. And so I don't think that there's any dispute that a lot of people are unable to afford legal resources when they want them, but how many people are in that situation and how big of a problem is that?
Right. And it was interesting. I think that some members of the bar didn't feel very heard. I'd have to guess that 90% of the comments that were left by members of the bar were against the program. And a lot of them did say that they felt like it was going to happen regardless of what they said in the public comments. So I hear that. I can see that that's a serious concern. But I also think that what lends some credence to the Supreme Court's action was that a lot of people who are independent of the Utah bar, who are out of state, were extremely supportive. I wrote down a few just to say the National Center for Access of Justice, Pennsylvania Law School, a retired justice of the Colorado Supreme Court, Duke Center on Law and Technology, Northeastern University School of Law, Vermont School of Law, Stanford Center on the Legal Profession, Responsible, People's Legal Aid. I mean, I could go on and on. I was shocked really to see the number of out-of-state organizations who are focused on this access to justice issue, who took the time to write very lengthy, well thought out public comments to Standing Order 15 and these other changes, really applauding the Utah Supreme Court for taking what some people do see as maybe an overly dramatic action to address this justice need. So there are two sides for sure. I think that I sympathize with both and excited to see how it goes. The last rule change that is a little independent of this is the changes to rules 7.1 through 7.5. Those are the rules on advertising. And these changes completely deleted rule 7.2, which talked about some specific advertising rules, deleted 7.3, which talked about solicitation of clients, completely deleted 7.4, which dealt with the communication of your field of practice within advertising, and also completely deleted rule 7.5, which talked about how firm names and letterhead should appear in advertising. And so they got rid of all these more detailed rules and just amended 7.1 to simply state that a lawyer should not make a false or misleading communication about the lawyer or the lawyer's services. And then it provided a little bit more context on what is considered false or misleading. So this very much simplified the lawyer advertising rules compared to what they were before. This wasn't a controversial change. Of those public comments that we looked at, I'd say a handful, maybe of the hundreds, even addressed the fact that the advertising rules were changed.
Right.
And of those, I don't recall one that was negative. I think this is pretty self-evident to anyone who communicates online or really any communication now. It's just changed so much since these rules were written that it's apparent to most people that this was a necessary change to really simplify these restrictions on lawyer advertising in light of all the changes. I had one case when I was in private practice that really highlighted why this was an issue for me. I represented a law firm in a disciplinary proceeding in front of the Utah bar, and the complaint had to do specifically with this firm's radio ads. And what the bar was really upset about, and again, it was one of these more archaic, detailed rules, but the bar, or the Office of Professional Conduct within the bar more specifically, had real concerns that the fact that this law firm liked to buy the radio spot that was, I'm sure we've all listened to the radio, you try to change it as soon as you can after the song, and right before after the song, a lot of times the DJ will hawk some type of a product. So it's not a produced ad with actors that you normally see during the commercial break, but it's just the DJ saying, hey, if you need a new mattress, you should go to XYZ mattress shop. And the bar was really concerned that these more extemporaneous exchanges would confuse consumers, that consumers wouldn't recognize that this was advertising. They would think this was a personal testimonial of the DJ. And so we didn't think
who just loves talking about legal resources in this spare time.
Because who wouldn't, really? Really, who wouldn't? But this was an issue, so we took the case all the way through a formal hearing, and we hired an expert, and the expert witness was a professor, up at the University of Utah. And this professor, he's a statistics professor, he did this very wide-ranging study with a lot of participants, and he played the participants different types of radio ads, and he asked them to recognize what was an advertisement and what wasn't. And not shockingly, what we thought would be the result was the result, which is that consumers nowadays are very sophisticated, and they understand when they're being advertised to, and that very few, if any, of the participants were confused by these extemporaneous ads right before or after a song played. They completely understood that these were paid advertisements, and notwithstanding that, we didn't, at least immediately, get the result that we wanted. So I'm wholly in support of simplifying. The very last change is to solicitation. So previously, Rule 7.3 limited any type of real-time solicitation of clients where it's for any type of pecuniary gain. And this completely does away with that and allows the real-time solicitation of prospective clients, as long as that manner doesn't involve coercion, distress, or harassment. And again, I think this isn't controversial either. It's hard to think of any type of communication nowadays that isn't real-time, whether or not it's posting on social media or texting or emailing. We're so used to all communication being real-time that to completely prohibit it just isn't workable. Although I will note the comments did suggest that lawyers make sure that they provide clients or prospective clients an opportunity to reflect before trying to engage their services. So certainly the direction from the bar is, be sensitive, let clients have time to reflect, but also this recognition that the communication is basically immediate.
Yeah. Great.
That's all I have.
That's it. All right. Thanks for joining us.
Thank you. Hello again. As luck would have it, the morning after we recorded the presentation, the Utah Supreme Court released amendments to Standing Order 15 and Rules 5.4a and 5.4b. The main change is that instead of having a separate 5.4a and 5.4b, they've combined 5.4 into a single rule. This new combined rule provides if attorneys want to take advantage of any type of fee sharing with non-lawyers, even if it's within that traditional law firm structure, that those attorneys still need to comply with Standing Order 15 and enter through the Sandbox, and will be subject to that authority of the Innovation Office. The Standing Order was also amended to reflect that slightly larger regulatory scope. Besides that, all of the other comments and discussion is still applicable. The Utah Supreme Court didn't make any change to Rule 1.5, so it appears that lawyers can still share fees with other lawyers, even if those other lawyers aren't actively involved in the representation. So lawyers can still take advantage of that new rule and also the new advertising rules. Again, the only change is that combined 5.4. So if you've made it this far, congratulations and thank you, and I hope it was helpful.